day to Mr. Akmal. We are from T3L1. My name is Rashmi Chandran. These are my groupmates. Now, moving on to the introduction of our presentation. Now, Malaysia's legal system is rooted in the common law, with English law forming part of our legal framework. Now, Article 160 of the Federal Constitution includes the common law in its definition of law, while Section 3 of the Civil Law Act 1956 allows the application of English common law, equity, and statutes in specific circumstances. Tun Ahmad Farouz Sheikh Abdul Halim and Tun Abdul Hamid Omar called for our own Malaysian common law system by reducing reliance on English laws. They advocated for a legal framework rooted in Islamic principles, Malay customs, and Malaysia's unique values, ensuring it reflects our identity and independence while upholding justice. Having our own Malaysian common law is crucial in balancing our diverse legal traditions. As a pluralistic nation, we must assert local values while ensuring fairness and inclusivity for all communities, preserving harmony and legal independence.
So thank you, Rashmin. My name is Claude Manager Fernandez, and I'll be talking about the role of common law in Malaysia. So as we all know, Malaysian law is mainly derived from British common law. This is because that during that time, Malaysia was a British colony, and the common law of Britain was implemented in Malaysia during that period. So upon gaining independence in the year 1957, the country still retained the common law of British as a key element of the legal framework up to this day. So moving on, the role of common law in Malaysia is enshrined in 3 sections in particular, which is Section 3, Section 5, as well as Section 6 of the Civil Law Act 1956. So Section 3 of the Civil Law Act, it mainly allows for the application of English common law, which is subjected to local circumstances and limitations. Moving on, Section 5 of the Civil Law Act is regarding the same thing, but it is more into the focus of commerce. Moving on, Section 6 of the Civil Law Act, it is in regards to land in which English common law is not applicable because Malaysia is currently implementing the torrent system of Australia. So furthermore, common law can only be applied in Malaysia in the presence of any lacuna, which is also known as the absence of any written law, or in the case that the law is silent on a particular issue. Or it can also be applied before the cut-off date, in which the cut-off date for Peninsular Malaysia is 7 April 1956, and for Sabah and Sarawak it is December 1951 and 1st December 1949 respectively. So an example of the case is a very famous precedent case regarding law of torts, which is Downey and Stevenson, which was decided during the year 1932. So in this case, since it is before the cut-off date, it can be applied in the context of Malaysia. So moving on, the Malaysian legal system also uses common law as judicial precedence, also known as the doctrine of stare decisis. This ensures consistency in any legal proceedings or decisions made in Malaysian legal system. So this can be seen in the case of Syarikat Batu Sinar Sdn Bhd and UMBC Finance Berhad, which applied English principles of contract law as well as English rules of interpretation. However, it is important to note that these judicial precedents are only merely persuasive and they are not binding to Malaysian legal system. So moving on, the application of common law is also subjected to Malaysia's local circumstances and customs. Of course, adapt these English common law to fit Malaysia's unique cultural, social, and legal context. For example, Islamic law and adat or customary law play very important roles in Malaysia's common law and land law, which limits the blanket application of common law principles. That's all from me. I'll move on to the next person.
Thank you so much, Mary Jane. My name is Ram Barma, and I'll be continuing on with the criticisms of English law and why there was a push for Malaysian common law. So, as per the article, Tun Ahmad Faris and Tun Abdul Hamid Omar have both called for reducing the reliance on the English common law. And they also cited in an article where Professor L.C. Green stated in filling the lacuna in the law that apart from any problem that might arise from the fact this legislation attempts, to some extent at least, to introduce a supplementary English common law and equity which may have become out of date and which may no longer be applicable in England, as the situation in Malaysia and Singapore is today different from what it was at the time of the enactment of those ordinances. Section 3 of the CLA, as stated earlier, supports the adaptation of English common law to fit local conditions, and reference may be made to the torrent system, where it's highlighted as an example of how Malaysian law blends various influences, such as the torrent system from Australia, and we can also look at English land principles and local needs. It has also been noted that Malaysia has developed its own statutory laws, and we may refer to them in the Islamic Banking Act, the Islamic Development Bank Act, and the Takaful Act 1984, which demonstrate Malaysia's initiative in creating distinct legal principles with Sharia frameworks. It was also established in the case of Rama and Leighton that Muslim law is not the abroad law, but rather the local law and the law of the land, and the court must take judicial notice of it. So critics then argue that relying on English common law undermines the national sovereignty and prevents the adoption of alternative legal principles such as Sharia law and in suitable cases. It was also stated by Professor Ahmad Ibrahim, who championed the development of Malaysian common law based on Islamic law and Malaysian customs, complemented by values shared by other religions. As we may refer here, despite the statutory cut-off date for applying English common law, lawyers and judges often follow recent English and foreign cases in deciding case law without assessing its compatibility with the Malaysian law, and the practical challenges of applying these legal principles that may no longer be relevant even in England. We may refer to the case of Syarikat Batu Sinar, Sendirian Berhad, and the UMBC Finance Berhad. They showed an example of where the court departed from an English precedent to follow a local decision that better considered Malaysian circumstances. We may also consider the case of Napline Sendirian Berhad and Jones Lang Wooten, where it mentioned a rare instance where the court applied the proviso to Section 3 of the Civil Law Act to reject English law legal principles unsuitable for Malaysia. Therefore, this shows that the reliance on English law should be reduced. In the initial article, it was stated by Tun Ahmad Fairoz that he described the judges as frogs under the shell of colonialism and stressed the phenomenon should not occur after 50 years of Malaysian independence. We should establish our very own common law. However, what are those ramifications?
Thank you, Ram. My name is Percy Kos. I'll be talking about the responses to the call for a Malaysian common law system. So as there has been a reliance on the current English common law system, many state that it's time for Malaysia in order to develop its own common law system. The British had brought their own English legal system to Malaysia when they had arrived in the year of 1786. So this led to the establishment of the COJ1, COJ2 and also COJ3. However, English law had been introduced unofficially through the residential system. So this shows the influence of English law onto the Malaysian legislation as it was modeled upon Indian legislation. So such instances we can take is the Contracts Act 1950, Penal Code and also the Criminal Procedure Code and more. So various justifications were used by English judges in order to justify the application of English law. So you can use the case of Motor Emporium and Arumugam. So in this case, the principle of natural justice was invoked, which justified the application of English rules of equity, which had no legal basis for application in the Malay states. So by looking at this, we can say that the challenge is Malaysia has relied on English law counters of types. So this has ensured legal certainty, legal insurity, and also legal consistency and predictability in the legal system. So without the continued reliance on the current English common law system, it shows that there can be uncertainty in the system and also impact the public trust in the judicial system. So moving on to the next slide, we can say that the next challenge faced is the practicality of the reform. This is because if we want to review the current English common law and replace it with Malaysian common law, it will take a lot of time and also a lot of resources which would be wasted, and also a lot of expertise needed by judges, legal practitioners, and also policymakers. So, critics such as Jason Loh Siong Wei stated in his opinion piece titled Common Law and Independence of the Judiciary, published in the Malay Mail, he discussed the importance of the current system and the risk of unnecessary reforms. This is because he stated that the focus should be on reforming the current law system instead of replacing it with a new one, as it might cause unnecessary complexity and also unforeseen circumstances. So you can see in the slide, this is also a picture from the article which can be referred to. So that's all for me. Thank you.
Moving on, I'll be talking about the legal basis for integrating Islamic and common law. So Malaysia has a very unique legislative framework whereby it consists of mixed jurisdictions and mixed legal systems, namely the common law and the Sharia law. So the issue of harmonization arose out of the negotiation which led to the formation of Malaysia in the year of 1963. So we can take a look at Section 3, Subsection 1 of the Civil Law Act 1956, whereby it provides for the application of English law unless it contradicts Malaysian law, public policy, or the Constitution. So this ensures that the English common law remains relevant unless it is overridden by the Malaysian legal developments. We can also take a look at Article 3 of the Federal Constitution, which recognizes Islam as the religion of the Federation and that ensures the place of Islamic law in the legal system. So moving on, we can take a look at Article 74 of the Federal Constitution and the Sharia laws. So under this, states have jurisdiction over matters relating to Islamic law in personal and family matters, whereby civil laws retain jurisdiction over criminal and civil matters that are not covered by Sharia law. Lastly, we have the development of Malaysian case law. So Malaysian courts have increasingly shown the ability to Malaysianize legal systems through case laws, adapting English common laws principles in ways that reflect Malaysian values, which can be seen in the application of the Islamic Banking Act 1983, Family Law Federal Territories Act 1984, and the recognition of Sharia principles in family law matters. So, moving on, since Islamic finance has taken its place alongside conventional finance, there are many procedural laws and substantive legislation that are based on common law principles that are related to Islamic banking law. So, Malaysia has decided to introduce a dual banking system in which existing conventional banking is practiced side by side with the Islamic banking system. So, in Malaysia, there is separate Islamic legislation and banking regulations exist side by side with those of the conventional banking system. So, Islamic banking was put under the federal list since it refers to commercial dealings, although Islamic banking actually falls under the purview of Islamic law. So that's all for me. Thank you.
Thank you, Purjit. Hey everyone, I'm Abhilash Murali, and today I will be exploring on the impact and implications of the Malaysian common law system. This unique adaptation of the common law system has not only shaped the legal landscape of Malaysia, but also evolved to meet the needs of its people and society. There are a few aspects I will touch on as I explain on the impacts of the Malaysian common law system. Firstly, the rule of law. The rule of law is one of the cornerstones of the Malaysian common law system. It ensures that no one, including government officials, are above the law. This is fundamental in maintaining justice, fairness, and equality within the country. Now, in a common law system, the role of the judiciary is crucial. Judges interpret and apply the law, and their decisions become binding precedents which are used in future cases. This system places great emphasis on individual rights and freedoms, along with the importance of a fair and equitable legal process. Take for example the case of Tan Teck Seng against Suruhanjaya Perkhidmatan, where Gopal Sri Ram interpreted the word life in Article 5 of the Federal Constitution as not merely referring to the existence of a person, however also referring to the quality of life, a healthy environment, and also a fair procedure for removal of a person from a public service. This case exemplifies how Malaysian common law system has evolved to reflect the unique needs and values, expanding constitutional rights in a manner which is distinct from its English legal heritage. One defining aspect of Malaysian common law system is its ability to foster legal pluralism. The system has evolved to reflect the country's unique cultural, religious, and social realities. The integration of Islamic law, Malay customs, common law allows Malaysia to maintain a legal framework that truly resonates with its diverse population. The argument for a distinct Malaysian common law system has been reinforced by Chief Justice Tun Ahmad Fairuz Sheikh Abdul Halim, who has suggested that Malaysia no longer needs to rely on the English common law system. He believes Malaysia has developed its own legal expertise, and legal systems should focus on creating laws that truly reflect Malaysia's unique needs, culture, and society. While the common law system has provided a stable foundation for Malaysia's legal framework, moving away from it will allow Malaysia to create laws that are more relevant to its citizens, addressing local concerns and needs. The judicial development in Malaysia, exemplified by the cases I have already stated, and shows that Malaysian judges have successfully adapted the common law to reflect local realities, thus giving it a distinct character. This approach not only fosters societal cohesion and legal pluralism, but also ensures Malaysia's legal system is both relevant and responsive to the evolving needs of its people and citizens. Thank you so much.
Alright, thank you Avilash. Now, to sum it up, the discussion on Malaysian common law system reflects Malaysia's journey towards a legal framework rooted in its cultural and religious identity. While English common law has been integral to the nation's legal heritage, the call to adapt it to local values emphasizes the importance of asserting sovereignty while respecting Malaysia's pluralistic society. A balanced approach is crucial to ensuring that the legal system remains inclusive, just and reflective of the diverse communities that make up the nation. That's all from us. Thank you.